Thank you, sir. I hope you don't consider the water that we put next to you some type of intimidation.
As long as it's not poured down my nose, I think I'm okay.
Yes, sir. I will recognize myself for 5 minutes. This is my turn in the questioning. I am very concerned about racial and ethnic disparities that exist in the criminal justice system. And I was pleased to see that you have raised this issue in your testimony. As you noted, these disparities are eroding public confidence in the system, not to mention causing injustice, which is the most serious grievance. I was pleased that the Department is convening a working group on sentencing policy, which I think will be very valuable. But I think it's much larger than simply sentencing. Disparities exist in law enforcement policies, in prosecutorial decisions, and other aspects of the criminal justice system as well. Shouldn't we be engaging in a full-scale review of the entire justice system and not simply the sentencing portion?
Well, I want to do that which I think is possible. My time as Attorney General is limited, and there are priorities I think that we have to set. That does not mean, however, that I don't agree with you, that we as a society have to focus, I think, on the larger questions that you raise to ensure that our criminal justice system, viewed in its entirety, is perceived as fair and actually is fair. I try to chop off those parts that I think we can get done during the time that I am Attorney General.
Possibly this committee could look at some of those other factors and we could work hand in glove, and I hope that we can, and that won't be looked as a, render unto Caesar and et cetera, and we'll work together.
I would be glad to work with you on that.
Thank you, Mr. Attorney General. The issue of deferred prosecutions is one that comes within the bailiwick of my subcommittee, Commercial Administrative Law, and also is one that comes to me as an attorney and as one who has a company within my district that has been the subject of one of the major deferred prosecution cases in New Jersey in the medical field. Many issues have been raised. The New York Times had an article by Mr. Ashcroft, I think, on the 5th of this month, and there were 3 letters to the editor on the 11th of May really condemning this practice, and it raises many issues. And I guess the big issue I'd like to ask you is, do you plan to continue this policy that of having deferred prosecutions and having what I understand the benefits are to corporations, but also seems like a double type of justice where corporations get to continue on and not have to plead guilty while individuals get sent to the gulag?
Well, I think we want to keep open to ourselves the full range of tools that we have in dealing with corporate wrongdoing. Very frequently, if you prosecute a corporation, you end up punishing innocents, people who did not engage in that wrongdoing, shareholders, other employees. And so I think you want to have a full range of possibilities. There are guidelines that we have in the United States Attorney's Manual as to when a deferred prosecution or a decision not to prosecute is appropriate. And as long as we follow those guidelines, I think it's good to maintain that tool.
Are those the guidelines that were issued in August?
I'm not sure exactly when they were issued, but I know they reside in the U.S. Attorney's Manual.
I think Mr. Mukasey had something in August that was certainly an improvement on deferred prosecutions. How is it determined on who gets to be the monitor? The monitors have been very lucrative positions, and Mr. Christie, I think a former Attorney General in New Jersey, who was, I think, at one time hired by Mr. Ashcroft, employed Mr. Ashcroft, and Mr. Ashcroft's bill in that case came to, I believe, $52 million for Zimmer Holdings in the case where he was appointed. Should there not be some type of neutral and detached individual to oversee and to act as an ombudsman type person to make sure that the corporation isn't subject to any type of charges that may be levied by these monitors?
Well, typically the person who makes the decision is the person who was in charge of the case, perhaps the U.S. Attorney, maybe the head of the criminal division at the Justice Department, but ultimately it seems to me the Attorney General is responsible for who is picked. And so I think that to the extent that we have concerns about who is being picked as a monitor, what charges the monitor is incurring, it's incumbent upon me to investigate, to look into those things and come up with systems so that we ensure that we are picking the right people and they are acting in an appropriate way. I mean, this is something that you raised with me earlier, and I think the concern that you raised is a legitimate one and one that I will look into.
Have a bill. I'm an original co-sponsor of H.R. 1947, the Accountability and Deferred Prosecution Act of 2009. It requires, among other things, that the department use guidelines providing for judicial oversight of the agreements. And I think that's a really important thing, to have the judiciary involved, and it requires public disclosure of deferred prosecution agreements and any agreement or understanding between an independent monitor and the organization monitored. So the department would support that, I presume, because it promotes transparency, uniformity, and accountability in deferred and non-prosecutions.
Well, I want to look at the bill, and I want to work with you in that. I wouldn't want to preclude or in any way circumscribe the ability of the department to be as creative as we can in formulating or using these tools.
The New York Times reported in May that 30 of the 41 monitors appointed in deferred prosecution since '94, which goes back to the time, I guess, when you were at the Justice Department with Mr. Clinton, were government officials, and 23 were prosecutors. Why is it that former prosecutors and government officials are more likely to be named monitors and receive lucrative monitoring contracts? Should that be the case?
I don't think that's an interesting statistic, one that I was not aware of. I don't think that we should be favoring one class of person, one class of lawyer over another. On the other hand, it may be that people who have you want people who have the relevant experience, knowledge of the industry. So I think you want to look for people who are qualified, people who are going to understand the serious nature of their jobs. But I do not think that we should we should reflexively look to one group of lawyers or a group of lawyers who have only one kind of professional experience.
And let me ask you one last question. The hate crimes law, which has passed through this committee, there has been questions posed as to whether or not it could in any way infringe upon a minister's ability to preach against sexual conduct, particularly homosexuality or other sexual conduct they may find abhorrent. Is there anything in the bill that you've seen or any time in history of hate crimes laws that have been on the books for years and decades, even involving sexual orientation, that have ever seen a preacher taken for his words and prosecuted, or for that matter during the civil rights days when preachers used to preach against civil rights or against integration or for integration or against loving v. Virginia and all that?
No, I'm not aware of anything like that, and obviously there are First Amendment issues that you run into when you come to making those kinds of determinations. You also have to have prosecutors who are going to use the tools that are given to them in an appropriate way. Prosecutors have a great amount of discretion, but just looking at the statutes that I think the House has passed and the Senate has passed, I don't see the fact situation that you've described as being problematic.
First Amendment, that's good. Thank you, sir. Thank you, Mr. Attorney General.